Be ready. 5 seconds. Start. The appellate being aggrieved by the decree for eviction preferred an appeal to the additional district judge, and since the court of the additional district judge is the final court of fact, we would set out the findings of fact reached by the additional district judge in some detail. The additional district judge, on an appreciation of the evidence, came to the following findings. The respondent was about 63 years of age when he filed the suit, but that was no ground for saying that he could not bona fide and reasonably think of starting a new business, though it was stated by the respondent in his evidence that he had in the past carried on business as a leader in iron and steel materials. That was contradicted by his own witness Ramlal, and it was therefore evident that the business of dealer in iron and steel materials, for which he claimed to require the Lohia Bazar shop, was totally a new business for him. The plea of the respondent was that he wanted to make a humble beginning in this new business, but even so, he asked for possession of the whole of the Lohia Bazar shop and not merely a portion of it. The respondent had not led any evidence to show that he had arranged for necessary capital to be invested, or approached iron and steel controller for the required permits, or made agreements to receive stocks of iron and steel materials. There was no material on record to establish that the respondent had made preparations from which inference could be reasonably drawn that but for possession of the Lohia Bazar shop, the respondent was in a position to start the new business, though the period of 2 years for which the lease of the Lohia Bazar shop was granted by the respondent to the appellant expired on 15th September 2014. The respondent did not take any steps to obtain possession of the Lohia Bazar shop for a period of about 2 years, and it was only in the middle of 2016 that he put forward the plea that he wanted to start business as a dealer in iron and steel materials and required possession of the Lohia Bazar shop for that purpose. It is true that the appellant had failed to show the respondent was carrying on business as commission agent or moneylender, but that did not establish the bona fide requirement of the respondent for possession of the Lohia Bazar shop. It was also evident that the object of the respondent in filing the suit was not to obtain enhancement of rent from the appellant, but that too was not a circumstance which lent any positive support to the case of the respondent. the burden of establishing that he bona fide required the Lohia Bazar shop for starting business as a dealer in iron and steel materials was on the respondent, and this burden, according to the additional district judge, held that what the evidence showed was mere assertion on the part of the respondent that he wanted to start business as a dealer in iron and steel materials in the Lohia Bazar shop, and that fell far short of the proof required to establish that the respondent bona fide required the Lohia Bazar shop for starting this new business. The additional district judge accordingly set aside the decree for eviction passed against the appellant and dismissed the suit of the respondent. This led to the filing of a second appeal in the High Court by the respondent. The High Court pointed out that the additional district judge had fallen into an error in holding that unless the respondent showed that he had made preparations for starting the business of dealer in iron and steel materials, such as making arrangements for capital investment, permits from the iron and steel controller, etc., it could not be held that he bona fide required the Lohia Bazar shop for starting such business. The High Court observed that when the respondent stated in his evidence that he required the Lohia Bazar shop for the purpose of starting business as a dealer in iron and steel materials, there was no cross examination of the respondent challenging the truth or bona fide of his statement, and no attempt was made on behalf of the appellant to show that the respondent was not in a position to start such business or that he lacked the necessary resources for that purpose, and his statement, coupled with the other objective and outward facts, must therefore be taken as sufficient to establish that he required the Lohia Bazar shop for starting this new business, and his requirement was bona fide. The outward and objective facts on which the High Court relied as supporting the assertion of the respondent were: firstly, the respondent had as far back as March 2009 sought to recover possession of the Lohia Bazar shop for the purpose of starting this new business, and it was not for the first time in the middle of 2016 that he dishonestly put forward this idea only with a view to securing possession of the Lohia Bazar shop from the appellant, and secondly, the respondent having closed down his grocery business and surrendered possession of the Sadar Bazar shop to the landlord, was without occupation for 2 years, and it was therefore natural for him to want to start this new business in the Lohia Bazar shop in order to earn a living.